Is the court about to overturn Roe v. Wade? And how could we possibly know that in advance? Good morning, ladies and gentlemen. This is Terry A. Hurlbut delivering you another declaration of truth. Today we have an astonishing development in the case of Dobbs versus Jackson Women's Health Organization. Someone, we don't know who, yet actually leaked a document purporting to be a draft opinion of a justice of the Supreme Court. It seems to show that the court is ready to turn abortion law back to the states. Or is it? That leak is either the most serious, indeed shocking, breach of security in court history or an elaborate fraud. And if it's true, and if that opinion becomes the majority opinion, get ready for the great sortation sooner than anyone could expect. That is, if someone didn't leak it deliberately to forestall that result. This is going to take a long time to discuss. So once again, I'm splitting this discussion into two parts. Part one, we'll cover the history of Roe v. Wade and how we got here. In part two, we'll talk about that document, whether it's real or not, and what its release really means. First, I want to shout out to the sponsor of this channel, which is Conservative News and Views. Link in the description. Be sure to check out the awesome CNAV Store. Scroll down to the bottom for that link. Lots of good merchandise there, including this t-shirt, Rhino Hunting. And I want to remind you, I am a published author. Look for 2 new books. Here's one of them, Matthew's Run, and its sequel, Matthew's War. They tell the story of what our country and our world might look like after 380-odd years of wokeness, and about a cyborg with a conscience who also just doesn't like to be used, leading a rebellion against it. They're available right now at Amazon and Barnes & Noble, to name 2. All right, ladies and gentlemen, pay attention. Class will come to order. And first, a trip down memory lane. The case of Jane Roe versus Henry Wade involved a defendant, Norma McCorvey by name, who gave the Jane Roe name to hide her identity, tried to get an abortion in Texas. Back then, Texas law made abortion illegal. Attorney Sarah Weddington, age 26, argued her client's case before the Supreme Court, having had very little experience. Nevertheless, by a vote of 7-2, her arguments prevailed. On January 22, 1973, abortion became lawful in every state in the Union. Now, technically, abortion on demand up to birth did not become lawful. Instead, the court defined trimesters of pregnancy in which different levels of state power applied. The decision did prescribe abortion on demand during the first trimester. The third trimester began with fetal viability outside the womb. The second trimester included every day in between. This led some wags to say that Roe v. Wade was a decision on collision course with itself. The reason? While techniques for abortion grew less invasive, techniques for saving the lives of premature infants also improved. Sarah Weddington died on December 26, 2021. Perhaps her dying shortly before New Year's Eve will turn out to be fraught with symbolism. Nor is Roe the only precedent for abortion. In 1992, the Supreme Court held 5-4 in Planned Parenthood of Southeastern Pennsylvania versus Casey that Pennsylvania could require the consent of a parent or guardian, if applicable, and have the woman wait 24 hours. But more broadly, the court warned states against imposing an undue burden on women seeking abortions. Now, what have states been doing lately? Let's start with the Gestational Act of 2018 in Mississippi and the case of Dobbs versus Jackson Women's Health Organization. The Gestational Age Act has a simple effect. No person may perform an abortion after 15 weeks. The Jackson Women's Health Organization, the only licensed abortion provider left in Mississippi, sued to block this law. A federal district judge first granted a temporary restraining order, then eventually enjoined the state permanently. The court said the state had not shown that the unborn child would be viable by then, and by the governing precedent, which is Roe v. Wade, no state may forbid an abortion until after an unborn child becomes viable. The Court of Appeals for the Fifth Judicial Circuit in New Orleans affirmed the lower court's ruling. Why did the Mississippi Attorney General petition the Supreme Court to review this case? because the composition of the court has changed radically. The appointment of Neil Gorsuch to replace the late murdered Antonin Scalia was not the key change. The key changes were the appointments of Brett Kavanaugh and Amy Coney Barrett. In addition to Mississippi's direct challenge to the Roe case, Texas passed its Heartbeat Act. But the Texas Heartbeat Act gives private citizens the standing to sue anyone who performs an abortion upon detecting a heartbeat or after the provider should have looked for a heartbeat and conveniently refused to do so. As such, scarcely anyone yet has standing to challenge the Heartbeat Act. Other than that, various states are already passing laws either to permit or forbid abortion within their borders. As of December 5th, 2021, 21 states already had laws to forbid or restrict abortion if Roe v. Wade falls. Texas is one of them. But CNAV has so far seen no evidence that a cadre of genuine pro-life activists is ready to enforce the Heartbeat Act. What we have seen is a legal troll filing a lawsuit hoping a court will stop him and invalidate the act. In the meantime, several blue states have passed various abortion sanctuary laws. They include California, Illinois, Washington State, Colorado, and Connecticut. The Connecticut law is a direct strike against the Texas Heartbeat Act, though how Connecticut proposes to enforce their law outside of Connecticut remains unclear. Also, Citigroup pledged to cover travel expenses for any employee seeking an abortion who must travel out of state to get one. The California law is especially egregious. It absolves woman or provider from any liability for a perinatal death related to an abortion procedure. Now that effectively legalizes infanticide up to 30 days after birth. That's the end of part one. In part two, I'm going to talk about that document, so stay tuned. Links in the description to the article, to the original Politico story, to the document purporting to be a draft opinion, and to conservative news and views. I have another link to the awesome online store, as I mentioned. And if you like what you've heard, you can like this video and subscribe to this channel. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.